Hello and welcome to One on One. I'm Vernon Ramesh and I'm very pleased to say my guest today is former Attorney General, Senior Counsel, Ramesh Maharaj. Mr. Maharaj, welcome back. It's always a great pleasure having you here.
Good to be here.
And I know you came straight from court, so we're privileged to have you here.
Thank you very much.
So many things to talk about regarding governance in this country, but I know specifically because of your background, you have some very strong views on certain legislation that is in train in this country, if you will. Let me start with the Section 34 business. Yes. I know you've expressed some views on it before. Most recently on this program, I had your former colleague, Mr. Pandey, who noted that he was fundamentally, as they say in France, in principle, in support of the idea of the whole reasoning behind Section 34, and that he felt they would have to bring it back again. What is your take on that?
Well, I do not agree that Section 34 was a good piece of legislation. As a matter of fact, what Section 34 did, that regardless of the delay and the reasons for the delay and the gravity of the criminal offense, the mere fact that there's a passage of time would entitle the individual to be freed. Under the existing law of Trinidad and Tobago, the common law, delay can cause someone to be freed as an abuse of process. But the Court of Appeal of Trinidad and Tobago and the Judicial Committee of the Privy Council have held that it will be against the public interest for delay in itself to free individuals who are charged for serious crimes. So that the court is given a discretion under the existing law to determine whether the delay which has occurred, if there's procrastination, undue delay, amongst an abuse of process of the court, because it is recognized that people should be tried speedily. But the court has enunciated certain principles which a judge must consider in applying the principle of undue delay as to whether the prosecution should be dismissed. And some of those principles include the seriousness of the offense, the reasons for the delay, because if the individual caused the delay, then it is unfair to the public interest to load that delay on the basis that the person should be freed against the public interest.
And of course, when you were Attorney General, you had several cases where the delays kept going on and on and on. And that is on the part of the client who is trying to defend themselves and forestall whatever judgment may be coming.
Yes, for example, that occurred with the death penalty. That if you, for example, file a constitutional motion and you are responsible for that delay, the court does not consider that delay as part of the conviction process and appeal process, because you have been the author of that delay. So I think that the government of the day at the time, when it proclaimed Section 34, and we must always remember that Section 34 came in at a time when it was decided to insert that section with certain guarantees given to the Parliament that it would not be proclaimed unless there were rules and procedures and everything in place. But that was selectively chosen by the Cabinet.
So it was pulled out of the legislation.
It was pulled out of the legislation to be proclaimed. So I do not think Section 34 is good law. I think that the law that we had before Section 34, and that is to say that give the court a discretion to decide on judicial principles whether delay should cause someone to be freed, is an important matter, because it gives the court the right and the jurisdiction to determine that. I do not think Parliament should determine that, or the executive should determine that by giving a blanket immunity or amnesty for persons who are convicted for serious crimes or who are charged for serious crimes.
No, I gather one of the bits of rationale that the government was using at the time for passing the legislation was that there was a serious backlog in the courts and there was no other way of dealing with it. And I believe Mr. Pandey said something similar.
But that's not correct, because there were other ways of dealing with it. If there's a backlog in the courts and the Attorney General believed that there is a lot of delays, he could have chosen all the cases in which there were delays, make a chart of it, and he could have made an application to the court for the court to determine whether these delays and the facts and circumstances of these cases merit the court declaring the matter as an abuse of process. But the citizen is protected by the courts. Citizen is not protected in legal matters by the government of the day to determine whether, if you have a precedent where Parliament can determine to free people and the government can determine to free people, then that is not due process of law. It's a violation of due process of law.
So you're saying constitutionally there's a problem right there, because
Yes,
it's violating the separation
yes,
between the various branches of government.
Yes, and quite apart from they selecting it to be proclaimed, because you have to remember that they having inserted Section 34, having given an undertaking to Parliament, not for it not to be proclaimed unless certain conditions were fulfilled. They went and selected this from the entire act in the dead of the night when Independence Day was being celebrated for it to be proclaimed. My point, however, is that the government knew when it was proclaiming Section 34 that the public would find out about it. They must have known that. And they knew that what they would do, they would then go to Parliament and they would pass a law to repeal it. But what they knew is that the objective of proclaiming Section 34 would be achieved even if the public found out about it, because it would mean that the persons would not be tried, because it will take years for the matter to go to the Privy Council, years. In the meantime, the persons would not be tried, and it would give the persons a defense that because of the delay, additional delay which has occurred, and the government's action, it would be an abuse of process to continue the prosecution.
No, I know you can't really speak to specific cases, but certainly in this particular instance, the judge ruled recently that in fact the entire legislation was unconstitutional and therefore threw out the appeal made by the defendants. What is your take on that? Is that, and of course, very shortly thereafter, the Attorney General said he was vindicated and the government was vindicated.
Well, the judgment has not vindicated the government. The judgment did not deal with the action of the cabinet in proclaiming Section 34.
And that's not what the court is about.
That is not what the case is about. The case is about whether the Repeal Act was constitutionally passed or not. So the issue that the judge decided was whether the repeal of Section 34 was constitutional. But the government has a right to celebrate, because they are celebrating because the purpose of proclaiming Section 34 has been achieved by the government, in that the fellas who are beneficiaries of this Section 34 would not be tried. They would not be tried for a hell of a long time, for another 6 or 7 years, at least. This matter is going to the Privy Council. And then the fellas could then say that because of that delay, it will be an abuse of process under the common law to prosecute me. So ultimately, the government knows that beneficiaries of Section 34 would be acquitted. So they have achieved their objective, so they're entitled to celebrate.
In terms of, there were some concerns after the legislation was passed and repealed that in fact some lawyers, perhaps not yourself, were concerned that you cannot retroactively sort of unenact a law that was temporarily enacted.
As a matter of fact, that is my view. My view of the matter is that if you pass a law and you give a benefit to an individual, you cannot retrospectively take away that benefit, because the law is not concerned with individual cases. The law is concerned with a principle. And the principle is, in my view, unless the law changes, unless the development of the law would change, the existing development of the law as I know it is that if you pass a law and you give a benefit to individuals, especially a person that they would not be prosecuted, you cannot then go and pass another law to take back what you have already given.
So in terms of the High Court judgment, was it simply to say that the government was constitutionally okay in withdrawing the provision and not making any judgment as to whether it was retroactively applicable?
Well, I think what the High Court determined, that the act which repealed Section 34 was not unconstitutional. But there's still another step, because there's still another decision to be given. And that decision will have to do that when the persons who are beneficiaries make an application to the criminal court, the question which would arise, whether at the time when they filed their application, there could have been any basis for having them to be put on trial again.
And they did file during that window, didn't they?
And they did file.
So that's a whole other legal pursuit.
Yeah. That is why I am saying the government knew. Remember, you have a senior counsel as Prime Minister. You have Mr. Anand Ramlogan, and they have got opinions from Mr. Alan Newman and all these set of lawyers. You have a new thing in Trinidad and Tobago. When the state has a case, and even if it's a simple case, you have a senior counsel and you have about 6 private lawyers. Taxpayers are paying all these lawyers for simple cases.
I think the bill was about $7 million.
Yes, yes, right? Yeah. So that the government knew when it proclaimed Section 34 that no matter what happens, the beneficiaries of Section 34 would not face trial, because we will pass a law to repeal it. That will take years. The fellows would have to take another point. That will take another 7 years. And under the common law, if you have such kind of delay of 10 or 15 years, you cannot prosecute anyone.
I mean, you were also a politician. I mean, would it be perhaps even reasonable to even expect any government to say, well, we're going to do this and then we'll repeal it? Because repealing in itself suggests a certain weakness of thought. That you would have to go and repeal your own legislation.
Well,
it would be a foolish thing to do.
The government, in my view, had made up its mind. It has 5 years to go. This was still 2 years in the administration. They have made a decision that they are going this way for whatever reasons, and they are going to proclaim Section 34, because the cabinet would have known at that time, by proclaiming it, these people would have got off. And they felt that they would have ride the public relations exercise and opinion and expressions, and people would forget it.
In terms of another piece of legislation that's in the process of going through Parliament, we have this miscellaneous provisions bill about defence, and the fact that perhaps some defence officers will be allowed to work with the police and have certain powers that are associated with the police. The Attorney General, the current Attorney General, has been arguing that that is reasonable, given the fact that the defence force already has certain responsibilities, and it's just adding to our existing ability to protect the public. What is your take on that constitutionally?
Well, I think the Attorney General is misrepresenting the true effects of that legislation. The vice in that piece of legislation is that it is going to give persons who are appointed by the political directorate, who can be transferred, who can be fired with political directorate influence, the powers of police officers. Under the existing constitution, police officers in doing police duties are not subject to the directions or control of the political directorate. In the execution of police duties, they have security of tenure, and they are protected by an independent service commission, the Police Service Commission. Under the Defense Act, an army officer can be appointed on the influence and directions of the Minister of National Security. The top level persons in the army are chosen by the political directorate. Under the Defense Act, the Minister of National Security has the power and the influence to put new soldiers. So the effect of that legislation would be that either existing soldiers who are under the political influence of the minister or the cabinet, or who can be manipulated because of favors, can do police duties. That is to say, arrest you, search your premises, concoct a charge against you, and it can be used as a political harassment machinery against persons who are opposed to the government. So the real vice in that legislation is to give them police powers. If the government was genuine of not using a private army, because what the government would then have, if that bill is passed, it would have the normal army, and then it would have soldiers who they feel would be on their side, who probably given them some favors, and they will have new soldiers who would be probably party supporters or persons who could be manipulated, and they can then be under the control of the Minister of National Security and the cabinet. So you can have two armies in Trinidad and Tobago, the real army, and you'll have a private army of the government in power. Now, if you study countries which were democratic and went to a dictatorship or military-style governance, you would see, as a matter of fact, there are two books which I have got. I can't remember the names, but it shows a study. Countries which are going to go into dictatorship, what they do, they allow the army to do police work, because then the politicians can control the harassment machinery against officers. We saw that happen in the Caribbean. We saw that happen in Guyana. If you remember what happened in Guyana, you had an army being controlled by Forbes Burnham. We saw it happen in Grenada. We had Eric Gary controlling the Mongoose gang. We saw it happen in Haiti. We had an army with police powers harassing people. We are seeing it happening in Zimbabwe, Mugabe. That is how it happens. That is how it happens in some parts of the Middle East. So I look at this piece of legislation not in terms of really fighting crime. Because if they want more police officers, you could bring in more police officers. If soldiers have too much work to do, you could make them resign, let them go under the Police Service Commission, let them be independent. As a matter of fact, I want to tell you something because this is very important. There's a very important case on this, a case of Endell Thomas and the Attorney General of Trinidad and Tobago. In that case, the Privy Council had to decide what was the role of the service commissions of Trinidad and Tobago, including the Police Service Commission. And the Privy Council in that case, the judge was Lord Diplock at the time, he stated that under the Constitution of Trinidad and Tobago, the reason why police officers are insulated from the political directorate is that if they were not, then police officers can become a private army of the government in power and the political party in power. And that can be a recipe for dictatorship and tyranny in any country. So you see what I'm talking about. But there's only one consolation I have in this. And that is that the government is so incompetent that the legislation which it passed in the House of Representatives is already unconstitutional. I'll tell you why. I'll tell you why. Where under the Constitution you have police officers being insulated from politicians, performing police duties, you cannot bring a piece of legislation and say that it is merely inconsistent with the Constitution, with a 3/5 majority. You have to bring a piece of legislation on which on the face of it, you have to say it is altering the Constitution. Because what the government wants to do is not to pass a law inconsistent with the Constitution. It in effect wants to alter the Constitution, modify it, in order to say that police duties can be performed not by persons who are under an independent service commission. So you need a 2/3 majority. So although the government may have had the majority in the parliament, in the House, even a 2/3 majority, the endorsement on the bill is wrong. And there's a case in the Privy Council which says that even if it has the right majority, but the endorsement is wrong, the law is unconstitutional. And there's a case in the Privy Council which has already decided that if you are going to change the terms and conditions of police officers or judges, you do not pass a law which is inconsistent. You're altering the provisions of the Constitution, and you need a 2/3 majority. So that independent senators must know the consequences of which they are voting, and I want to tell them publicly that if they vote for this piece of legislation, they would in effect be voting for military dictatorship in Trinidad and Tobago. And in any event, the majority which the government needs is not a 3/5 in the Senate, it's a 2/3 majority. And even if they pass it with a 2/3 majority, the way the bill is endorsed with a 3/5 majority and inconsistent with the Constitution, it will still be unconstitutional. So the bill cannot be remedied in the Senate. The bill has to be withdrawn. Otherwise, there'll be litigation in that matter. As a matter of fact, I could tell you today that I am going to make my opinion available to the press by this weekend in this matter. I have got that opinion checked by 3 Queen's Counsel in England, and we are ready to challenge that law if it is passed in its present form.
And you're saying that obviously as a former Attorney General and as a constitutional scholar.
Yeah.
Interesting you mentioned the independent senators, because one of the results of the last delay in the Senate was that you had some government ministers criticizing independent senators and saying that, you know, they were acting like a political bloc. What do you make of that,
well,
given the role of independent senators?
I think that's a serious matter, and as a matter of fact, I am disturbed that the Prime Minister has issued an invitation to independent senators to come and meet with them in order for them to explain the bill. Now, that is unprecedented in Trinidad and Tobago. The reason, if you look at the Constitution, the reason that you have independent senators, you have senators appointed on the recommendation of the government, on the recommendation of the opposition, and then the President has an independent discretion in appointing independent senators. And the purpose of that is for the independent senators to be the check and balance against any government which wants to do what it is doing now. And therefore, if the Prime Minister decides to call them in, it is going to fall within the principle of apparent bias. Because as you know, it is not whether the independent senators would be actually biased or not, but whether the public would believe that there's a possibility of them being biased. You remember the famous case in Trinidad where Mr. Pandey was being tried. The chief magistrate merely had a meeting with the Attorney General, not in relation to the case.
And all hell broke loose.
And all hell broke loose. So it's apparent bias, and what the Prime Minister should know, that apart from it being improper, it will in effect be telling the population that the independent senators are biased, apparent bias. And as a matter of fact, I personally believe that the President of Trinidad and Tobago should intervene and should tell those independent senators that they should not accept any invitation from the Prime Minister to discuss this matter. Whatever the government wants to tell them, they could tell them in the Parliament. They can publish a document and they can send it to them and they can read. But to call in independent senators, to have a meeting with them, is creating a serious precedent, because it means then that from an apparent bias point of view, you no longer have independent senators in Trinidad and Tobago. They are now government senators and you have opposition senators. So by accepting that invitation, the independent senators can, I think, make out a case against themselves for instant removal as independent senators.
We have about 4 minutes left. I have to ask you, with regards to your former, I don't want to say partner in crime, but certainly your former colleague, now Minister Warner. What is your take on his apparent Teflon nature when it comes to politics? Nothing seems to be able to stick on him or touch him politically in terms of his position.
Well, I am baffled because the Prime Minister in opposition, if you check the Hansard, check your news stories, called for the removal of Mr. Calderhart on the basis of allegations against, that was against the chairman of a board. Mr. Jack Warner, in opposition, also called and accused Mr. Manning of prostituting the Constitution of Trinidad and Tobago, lack of integrity, and in effect, unfit to be Prime Minister. And I did the same thing in the Parliament. That was the opposition position. So the question is not whether there is guilt or innocence. The question is, are there serious allegations against a minister of government? Now, this is a minister of government, not a chairman of a board. There's a cabinet minister. And if there's a serious allegations against a minister, the proper thing to do is either the minister resigns, and if he does not, the Prime Minister has to remove him, because it contaminates every citizen in Trinidad and Tobago. It is bringing in disrepute all the young people, the students. It is an act of contempt against every person in Trinidad and Tobago. What the Prime Minister is doing here is not an injury against herself and a government alone. It's an injury against a country. It's an injury against every citizen in Trinidad and Tobago. It's branding every citizen in Trinidad and Tobago as being with no values of integrity or honesty or fair play. Because as a government and as a leader, you must send a signal as to what are the values and the high standards of conduct in public life.
Now your former boss, who was on the program I mentioned recently, former Prime Minister Basil Pandey, nearly had me fall off my chair recently when I asked him if there's anything he would change looking back on his life and his career. And he said the first thing, the only specific thing he mentioned, was he feels perhaps he could have treated Ramesh differently when he was in his administration. Does that surprise you? I mean, given there's been so much back and forth over the years.
No, I think when you are no longer in public life, you reflect on matters, and I think when you really look at the politics of Trinidad and Tobago, if the UNC had a different kind of leadership in succession to Mr. Pandey, the UNC probably would have been in a better position, and if I may say so, the country would have been in a better position. Both Mr. Pandey and myself took the position before Mrs. Vicessa was elected leader. I wouldn't talk about elections, what it was, that she was really not going to give the UNC and the country the right kind of leadership. And I regret very much that I didn't get the opportunity to give the country some of the leadership I gave as Attorney General of Trinidad and Tobago. But that now is history. But I think Mr. Pandey still has a very important role to play in Trinidad and Tobago. I know he's no longer interested in electoral politics, but I think he has a very important role to play. And I think that his role can be in helping to rescue the UNC, or save what it is of the UNC. Because as the founder of the UNC, I think he must be very disappointed how the Prime Minister of Trinidad and Tobago has brought the UNC into total disrepute.
Well, kind words in both directions. I'm really kind of surprised, but it's good to hear. Ramesh, Lawrence, Maharaj, it's always a pleasure having you on the program. Thank you so much for being here. Thank you.
Pleasure.
You've been watching One on One. Join us again tomorrow for another edition.